Hi, I'm Luke from Bigmore Wills Probate. I'd like to talk to you today about your will and divorce. Lots of people think that if you get divorced, your will is automatically voided. This is untrue. If you get divorced, your will is simply read as if your divorced spouse has predeceased you. This doesn't mean that you don't need to rewrite your will. It is important to rewrite your will because I can guarantee that it will be very different without your spouse in it. And there are a couple of points that are really worth thinking about. Firstly is who you would want to be the guardians of your children. Your divorced spouse will automatically have parental rights if they are the parent of your children. So that guardianship clause will need to be changed. And then there's a few other points that people don't always think about. And firstly is if you get divorced and you own your house as joint tenants, you think that actually one of the divorced parties stays in the house, it's all quite amicable, and if anything happens to them, you'll get your share out. Well, that's not true, because the surviving partner will take the property in its entirety, and then it falls into their estate. Well, if they remarry, all of a sudden your children could end up losing a large percentage of their inheritance. So on divorce, it's really important to sit down and think what's important to you, what are you doing moving forward, and how you can amend your will to reflect your wishes post the divorce. And further considerations that you might want to think about in your will after divorce is you could have chosen your spouse to be your executor. If you haven't chosen reserve executors, this will be a problem because it will be read as if they've predeceased you, so therefore your will won't have any executors. And if that means that your estate is going to children that are under the age of 18, they won't be able to act either. So it could be quite expensive to administer your estate because you'll have to use probate professionals. You could have chosen to get buried next to your spouse. I dare say that that will change if you've got divorced. You could have provision for pets. You may not want your pets going to your spouse's sister anymore, for example, so that may well have to change. And other little things, like you could have earmarked a family heirloom to go to your spouse and without having any reserves. Well, if that's the case, it would then fall into your residuary estate, which means it could have to get sold to get distributed evenly amongst the rest of the beneficiaries. If you'd like to discuss this, please speak to a professional or ourselves, and we can talk you through the process.